that are way off the charts in my mind, but.
Right, I believe you testified that on direct, that I can't believe I was saying this sort of thing.
Yeah.
But he rejected that, right? He said, no, I don't want you to reverse the ruling.
I don't remember right now, whatever I've said is fine. I don't remember what his responses are.
Cross-examination.
Alright, Mr. Let's go to you. So, will you testified on direct examination, obviously, that you are, when you're not sitting as a judge pro tem, you're a full-time attorney with a civil case law?
Civil cases, yeah, it's a civil litigation law firm, primarily.
What is that? I mean, I don't know, you and I obviously work in the legal field. Can you explain maybe just a little, I don't know, as brief as possible, what civil litigation is, or what that means?
This is where people or entities or a mixture of both have claims against one another. In other words, it's a plaintiff and a defendant, co-defendants, as opposed to state versus Blandino, that kind of thing. Okay. So it's basically, it could be government entities too, in other words, state of Nevada versus Clark County. But it's usually suing for like money, things like that, as opposed to being charged and possibly facing jail time. So civil doesn't have anything to do with the jail time.
Right, so for example, so your clients wouldn't necessarily go to jail, they would maybe owe money for breaching a contract or something to that.
More in the lines of injury, in other words, like if you fall at Caesar's Palace and you sue, then maybe I'd be defending Caesar's, that kind of thing, if that makes sense. Slip and fall in a bathtub or something at a hotel, then maybe I'm defense counsel, that's kind of the way it works.
Okay. And, all right. And, so, I mean, it's that you said, so you're suing for money, so you're like negotiating with other entities or other people all the time, is that accurate?
For money, yes. I mean, it's usually money, or if it's a casino, it could be somebody looking to pump their player's card, things like that.
Oh, yeah, that's,
Just negotiations, usually within the realm of money, at least in my job. I don't know what other people do, but not too much, not really that many contractual matters. Unless it's like indemnity agreements, some things we don't need to talk about, it's too complicated. Yes?
Okay. So you, sounds like you mostly do sort of defend sort of negligence claims, is that?
Negligence and intentional torts.
Okay. All right. And now we saw, obviously, you went through the video of the, we saw the video of the traffic trial in, back in August of 2018. You did mention that there were people behind the bar, right? When you, those were people most likely waiting to have their case heard.
I saw that, and I also saw a few attorneys that I recognized for appearing in front of me or just knowing, yes. And the police officer that actually testified in his trial. So there were multiple people around or coming and going, just because there's a lot of cases.
Right.
But
it's also, I mean, the courtroom is open to the public as well.
Yes.
Okay. And really, I mean, as long as someone's not disruptive, they're welcome in the gallery of the courtroom.
Agreed.
And in
Being
that,
paid by taxpayers, so, generally speaking, how people just start excluding people randomly without, cause, so I agree.
all right, and sorry, just going through some of my notes here. Okay. I know that one of, in that, the trial, you noted that Mr. Blandino, prior to that trial, had filed a motion. Can you just maybe explain to our jurors, what's a motion? I don't know, they might not understand. What is that?
I don't think he filed anything before the trial, but he made mention about doing so, or maybe during the trial.
on the traffic?
I'm not really sure what he was doing, but I don't think he had filed anything yet.
Okay.
Other than that motion that I was hearing, I don't think there was anything against me. I'm not trying to correct you, but
No,
that's
I'm talking
that's
about
my
a motion,
understanding.
right, for that traffic trial.
Yes, but a motion is a request of the court to do something. For example, in his case, I think it was to dismiss all charges because his case did not go to trial fast enough because maybe it was continued once before. And then he had several other things like something about his religious beliefs and a few other things. And I only remember that because it was on the trial, so I have as good a memory as everybody else watching for the most part.
Right, basically, so it isn't, so a motion is something, right?
Motion
It's basically a request for the court, the judge to
Yes, Your Honor.
do something to make a decision. Okay.
Yes, sir.
In that context. And then one of the other things that maybe I just want to make that are, you said to him, I believe he said something and you sort of stopped him and said, you've made your record. I just want to, what do you mean by that, just so our jurors understand? Like when you say you've made your record, what do you mean by that?
Well, I mean, you want to get out on the record in case there's some kind of appeal. Things that you say to protect yourself. In other words, if you don't object to something that shouldn't have been said, then later on if you make an appeal, you really can't complain about it and get the ruling reversed. You want to make your record, have your arguments in case, for example, in federal court, the case goes to the Ninth Circuit. Having a record, transcript, audio, video recordings like we probably have here today and over there. You want to have a record of things so you can go on if you lose at the level that we're currently at.
Okay.
Just like you do here for this case, I guess.
All right, thank you. And so now, obviously, so we saw that, and we fast forward then to April 8th, where April 8th, 2019, Mr. Blandino goes to your office. And was it your testimony, were you present that day in your office?
I was in my office, yes.
Okay. But it was your instruction to the receptionist, tell her, to tell her that you're not gonna meet with him, or that you weren't there, or what exactly, if you recall, what was your?
It could have been any of those. The bottom line is, I'm not gonna deal with this right now. If I talk to somebody that I don't know, and they get a hold of an attorney, you're not gonna get them off the phone for a while. I have an obligation to clients that I'm dealing with right now. So something along those lines, it could have been get rid of them. It could have been anything. It's like, hey, I can't deal with this right now. I don't have anything scheduled, and I'm sure I was doing at least 5 different things at once for clients that I'm obligated to handle their tasks for.
Okay.
In civil litigation, you usually have stacks of paperwork on your desk. You have to have a big desk, and you also have things on your floor, because you have different things that are kind of looming, so to speak, getting phone calls, writing briefs. So it's a lot of, as opposed to criminal, it's a lot of paper pushing. A lot of paper pushing.
And a lot of balls in the air at the same time.
Multitasking, I like to say. You gotta be a good multitasker in civil litigation, and criminal.
Thank you. Okay, okay. So, and as you recall in that April 8th letter, that he said that he came to you because or something to the effect that his religious beliefs required him to do so. You recall that?
Whatever the letter says is what it says.
Okay.
Yes.
And, I think he used the words probably negotiate a settlement, maybe he wanted to sound, I don't know, more formal for you, but, really, I guess if you put that letter in context with later talking to him, you get the impression, or is it your impression that he really just wanted to sit down and talk to you? Or?
No, I never had that impression at all.
Okay.
I felt like he wanted to get at me.
Okay, and when you say he wanted to get at you.
He's a disgruntled former defendant. In criminal cases, as you're aware, there's a winner and there's a loser. And the losers will never be happy with the results. Sometimes they're okay with it. They just have their day in court. And obviously, people that don't prevail, they have their remedies. They go and make these complaints. They can contact the judicial the Commission on Judicial Ethics, excuse me. But you don't go after the judge outside court. That's not part of anything that, to me, any reasonable person would do. I certainly would never do something like that if I was in front of a judge and I wasn't happy with the ruling and I thought they did something wrong. Never in a million years would I go looking for that person's work or possibly home.
But also, you are a licensed attorney of 25 plus
No,
years as well.
about
I mean,
26.
it does make a difference.
What do you mean?
Well, I mean, as your way of thinking as opposed to someone who's not an attorney licensed by.
You know, I've heard thousands of cases, I've represented thousands of clients. This is the one and only time that this has happened, so I wouldn't agree
Okay.
respectfully.
All right.
This is an outlier, counsel, so I mean, not to argue with you, I apologize, but.
Okay. So, so then so you didn't contact him at all after the April 8th?
No,
Yes.
no,
Right.
no, I want that person away.
And it was your testimony that was, I believe it was that day or next day, I think it was the next day you said you went to file a police report? Is that correct?
Yes, I did, and along with other things too, like telling people of the city, watch out, there's a rogue defendant around.
Okay.
If they're coming after a pro tem, what about the quote, real judges that are full-time, when they're there every day? I'm only there once in a blue moon.
All right.
Shouldn't say that, sometimes it's more frequently, but I'm not there that often, like Your Honor here.
And, okay, you said I believe you said you've been a pro tem judge since 2001?
Justice Court, I started in 2001, that was my first appointment, and municipal court was 2003, along with other titles as well.
Okay. And, just briefly, can explain to our viewers, what's the difference between a justice court and municipal court? I mean, municipal court is the court for city of, well, in this case, the city of Las Vegas, is that correct, is that accurate?
Municipal court is for the city, it's only misdemeanor cases, and it's only criminal or, I guess, traffic matters. In justice court, that's where all cases start that are criminal, whether it's a trespass case or whether it's a battery with use of deadly weapon or a murder. They all start in justice court or.
Okay, and
Similar
that's run by the county, right? I mean, these are.
Correct. Those cases go up to this level afterwards.
Right, okay, so there's different sort of, what do you call it, government entities, I guess, that oversee each court.
It appears, I don't know all.
The city, justice court of the county.
Yes, like I was saying on direct, I'm appointed by the city for municipal court, which was this case, and I'm appointed by the county commission for my justice court roles.
All right, and we had already, I guess, said that the courtroom is a public forum, so but Mr. Blandino was within his rights to go into your courtroom on April 25th. Was he not?
Absolutely not after he sent me that extortion letter, no way. Not in my eyes.
All right.
You obviously disagree, but no way, I mean, as you saw from the video, I mean, I'm usually pretty firm but fair. I stopped and I think I
He
started
wasn't
talking.
being disruptive, he just came and sat down, he wasn't.
The fact that he came in
Mm-hmm.
after that letter he dropped off, threatening letter, and me knowing a criminal investigation was going on, that was certainly disruptive to me. I mean, obviously nobody else knew except that I kind of froze for a second, as you saw in there, but to me, it was extremely disruptive. I was at a loss for words and I couldn't even speak to the defendant. I was so thrown out by the fact that this individual, after having the nerve to come after me at the office and suddenly show up at a courtroom that I'm almost never in, that was extremely disruptive to me. And that's why you gotta go. I mean, you can't be trying to extort somebody and then show up in the courtroom, and I have that right to remove them. And I didn't so forcibly. I didn't ask for marshal or say, you're in my courtroom, you're in contempt. I mean, my response was, I think like anybody would, with a reasonable mind, you gotta go. You know, get out of here. I mean, I was concerned.
Okay.
I mean, there are defendants sometimes in cases that try to come at the judge, and anything can be used as a deadly weapon, as you know.
But I mean,
You gotta have-
there's a rigorous screening process here, to enter the Regional Justice Center.
Not for pens and
Correct.
pencils, for firearms and knives.
Okay, and I mean, you have armed marshals in your courtroom?
Usually one,
Okay,
and the one might be sitting over there, and
okay,
I stay on a first name basis with the marshals, just so that they know if I say their first name, they know I'm reading somebody wrong, and there might be a problem, and then they get out,
Okay.
that's kind of the way, sorry.
okay. And, so, but I mean, were you frightened, or what were you, what were you saying, you froze when he came in on the 25th?
Well, you know, the person coming to my office once, that I've never had happen before, that was obviously horrible. But then the fact that he found me in court randomly 2 or 3 weeks later and showed up, certainly was no coincidence in my mind, because I'm not sitting there every day. My office is where he found me, way up on the northwest side of town, not down here. So me just, probably was the next time I sat after that was over there, and that was kind of more frequent than I usually sit, because I have a full-time job. You know,
How frequently do you sit for municipal court?
sometimes it could be a few mornings or something in a row if somebody's out sick or there's an open spot, but usually at most it would be once a month on average. Sometimes you can go 6 months without sitting. It's very, in general, it's very infrequent. However, there are,
Once a month, you say?
I would say on average, if you looked at all the sittings once a month, but you could have like 3 mornings or morning and afternoon. It varies, but on average, I comfortably would say, back then anyway, when I had more time on my hands, probably once a month was an average, saying that
Okay.
some weeks, maybe twice in 1 week. Some months, none at all. So I'm comfortable saying that, but I'm not 100% accurate, probably even 75% accurate on that.
Okay, and, well, so then going to, so then obviously we heard your testimony of him dropping off the letter, which led to you calling him, I believe it was on April 29th?
That sounds right.
Okay,
It's kind of hard to hear you because I hear a lot of paperwork, I don't know. Sorry,
okay.
it's a little distracting.
I apologize.
All right, and, well, you stated, you did not want to call Mr. Blandino, is that correct?
Oh, no, I think it's correct. I absolutely do not want anything to do with this individual.
And so but you called him at the insistence of the marshals, of the detective and the marshal.
They didn't insist, I mean, they asked for my cooperation, I'm the one that started the process, of course I'm gonna cooperate, otherwise it's kind of being.
So you did so then at their request, maybe not insistence, but at their request?
To facilitate their investigation, I guess is a better way to put it.
Okay.
Yes.
So-
I didn't do it because I wanted to, or because it was my idea, we'll put it that way.
Okay, so the idea to call Mr. Blandino came from these law enforcement detectives?
You can imagine the call after seeing the trial, how
Right.
much he talks.
Yeah, and so when you, I believe you, your testimony was that he was, I guess he was surprised when you called him? Is that how you would categorize his?
I would say delighted and giddy.
Okay.
I
I believe you
believe-
said giddy at your grand jury testimony.
I didn't,
I believe you did, use that word giddy.
that was a couple of years ago, I'm just telling you what I remember. I can hear him, but obviously I'm not gonna, I mean, I've had thousands of telephone calls,
Right,
you know, but
but never one quite like this, where you've got, you know,
Right.
marshals sitting in on you, I mean, as soon as some price stand out. a
he
little bit.
repeated at least 3 times, I cannot believe that I am speaking with Michael Federico, and you could just, you know, it's just like reeling in the fish, those telephone scams. It's just a matter of, okay, he thinks he's got one over on somebody finally, after whatever all of his attempts. That's what it sounded like, I'm not saying that's true, but that's what it sounded like. And
Okay.
I remember I kept shaking my head at the officers, I'm just like, you know, because it's humiliating knowing that he thinks he's got one over on me like that. It's just, you know, if it's a blow to any ego you might have, it's embarrassing.
But I mean, he told you that, I mean, he's made these, he's written these letters before, but no one has ever called him back, right? Did he mention that? Do you recall that? Him mention
So, something like that, you know, he was very impressed with himself that finally his scam had worked. That was my impression, for lack of a better word.
Okay. And, I mean, he said that every prior incident, the judge previously had just ignored it. You recall him saying that? Words to that
No,
effect,
I
because
don't, sorry, did you finish? I apologize.
Well, I mean,
I didn't hear the question, Counsel, I'm sorry.
okay, so I mean, he indicated on the call that, you know, he'd written these letters, but every prior incident, he was just ignored.
I think so, I can't swear to it, but he probably said it, I don't have an independent recollection.
Okay.
Some-
But that would
something
probably
like
be
that.
consistent with the types of things he was talking about on that call.
If one of the officers testified to that, I would be 100% agreement with it, because they were paying more attention, I was just kind of focused on the goal and hoping to get off the phone with this guy.
But in fact, they were taking notes. Did you observe the officers taking notes of the call?
I thought maybe there were, but, you know, years later, all I remember is, well, I didn't remember, I found in my folder those 2 pieces of paper that you were able to see with their notes that I read earlier.
Yes, and
I forgot the exhibits. But
They
I'm sure that they were, because they had to keep track of what was going on, I just
Correct.
wasn't paying attention, I was nervous.
Very well. Under the laws.
All right.
Those are the originals too, obviously.
Correct. So I'm showing you, if I may approach you, showing you what's been previously marked and entered into evidence as State's Exhibit 33 and 34.
Thank you.
Glasses. And do you recognize those as the notes that the detectives gave to you?
Yes,
Okay. And so they were,
I mean, it was kind of passed by, I mean, I'm sitting on one side, I think they were on the other side, and the phone was in the middle. And either they were showing me or passing back, and I'd pass it back and put my hands up in the air because that wasn't working, and then something else would be written. That's kind of the way, it was a fluid process in an effort to get more information from your client.
okay.
So that's the way, I remember that. 'Cause I was
So this
really
is-
nervous.
Okay, so this is one of the notes there. I don't know if you can read that and then,
You want me to read both of them, sir?
well, I mean, sure. Looks like there's 2 questions there. Been written in writing, yeah. Read there, number 1.
What are your terms of settlement? And number 2 is, what do you want to see happen?
Okay, so you, on this call, you asked the questions that they told you to ask, is that correct?
Yes, or try to put my own spins, or I might not say exact quotes, but
Well,
I
words
got,
to this effect, I mean, you,
I understand.
but you understand what I'm trying to say? Maybe not verbatim, like, what are the terms of your settlement?
They are the pros, they are the experts, and I'm trying to follow their advice, they're trying to help me so that we can make this a 1 telephone deal, because they knew I didn't want to make that first phone call.
Right.
That was what was going on, is I'm throwing up my hand saying, hey, he wants to meet in person, what am I supposed to do here?
Right, and I believe you testified that, yeah, let me get that. I know, it's over there. There you go. Thanks. Okay, so you, say that again, you want to make this a 1 phone call deal?
You know, I did not want anything to do with your client, I just wanted him to go away, I didn't want anything to do with it, and obviously I was forced to proceed with law enforcement, which I didn't really want to. And the least amount of contact or engagement as possible, I mean, and it's not just a selfish thing as far as, well, you know, yeah, I gotta work. You know, this is, you know, I got my own life to do. I mean, I just didn't want to deal with an individual like that would come to my private law office.
Okay.
And knowing more importantly, the way he was in that trial, and how firm I had to be with him, and how difficult he was in his voice, I just wanted him to be gone.
Okay.
So,
But you didn't ignore him, you engaged him at the insistence here. So what I guess, what
Well, there was, like I
you
said,
said
there's-
is it
Give
was
one at
the,
a time.
sorry, the
one at a time.
idea to call him was from the law enforcement officers. It wasn't your idea, and it wasn't your wish to do so, is that correct?
That's correct.
Okay, and so that did you, and then let me show you what's exhibit 34. Here's some notes, it looks like you can read those. Did you also ask these, or did you say these things to Mr. Blandino?
Either I said them pretty close to theirs or something with the same meaning, yes. I would have said anything that they asked me to that you see in these papers.
You would have,
I agree.
okay. And it says, looks like top letter, I'm an attorney, I'm not going to go blind into negotiations. And it looks like that second sentence there says, try to get clarification prior to meeting. And then it says, the last part there, it says, ask what happens if I don't agree to meet? Because now that question, what happens if I don't agree? Mr. Blandino was insistent on just meeting you, right? And wanted to talk to you.
He wanted to be in my presence for something, yes.
Okay, just
He
to.
wanted to be around me. It
Uh-huh.
was very,
Okay,
I want to call him names, but it was very weird.
okay. And, no, I get that this is, out of the, out of the ordinary. But the question is, I mean, he didn't really want, what he wanted was just to, sit down and meet with you. And in fact, I guess, you indicated he was insistent, I believe is what you said, or what, something to that effect, that he insisted on meeting with you.
I would say insistent or obsessed. I didn't know what it was when, on the 25th,
This is
you know, I even said, hey, I said, stop stalking people. And that's the way I felt.
Right. And, those are your parting words at the,
It was.
at the hearing of stock people. I mean, that doesn't really sound like someone who's scared to you, or, I mean, does it? Does it sound like someone who's?
I would say, based upon just seeing him, what was going on, I was pretty much stunned and shocked. And
Yeah, I
I'm
mean,
glad that's
like-
all I said. I'm sorry, I didn't mean to interrupt you.
No, just, don't stalk people. I mean, that sounds like someone, I don't know, kind of sticking to, like, as he's leaving, like, get out, don't stalk people.
Well, let's put it this way, I
Mhm.
believe whoever the marshal was, they escorted me out of court and to my car that day.
Okay,
There was a lot of concern there, no matter what I had to say.
okay,
It's not like, there's any backyard justice or anything like that. I mean, I'm sitting on the bench, there's somebody
Right.
victimizing me, and I was concerned. I could have called him a lot of names, we'll put it that way.
understood.
So calling him just a stalker, I think was the least of what I was probably thinking in my mind, to be honest with you.
Fair enough.
So,
Okay, and, so, in fact, so, on the call, even though, he approached you to quote, unquote, settle matters, when you called him, he really had nothing prepared to offer, is that correct? I mean,
to offer him, I had nothing to offer him.
not him, like, when you said, what do you want? He really had nothing to say, I mean, he had to.
No, I think it really, it's been a couple of years, but I believe, because it was like a 20-minute phone call. I think your client said 18 minutes somewhere or whatever. It was really him insisting on me, he needed to see me, he wanted to speak face to face. That's how it went for the most part. And then when we really tried to nail him down, he said he had to think about it. Something like that, not exact, I don't remember exactly, but he had to think about it and he'll get back with me. That's when he calmed down out of kind of more of like a manic state and kept on rambling on. He did say that, because the phone call obviously, I know got me hanging up on, unfortunately. So he kind of mellowed out and realized I wasn't gonna be with him face to face, at least not right there.
Okay.
That makes sense.
Yes, so I mean, he asked for a few days to think about it because he didn't really have anything prepared to say, I want this and I want that.
Well, I mean, I caught him off guard because he didn't know who it was, and like I said, he was like a giddy kid when one of the times when he was, I can't believe I'm talking to Michael Federico, where you could just hear it in his voice. It was a different voice than the voice that you hear, a different tone. He was very,
Okay.
very, very giddy, delighted,
Right.
and it was making me sick knowing that he was so excited about it. So that's the
Okay.
truth.
I'm just gonna ask you, your opinion, does it strike you as odd that he didn't have a list of demands or requests at the ready? I mean, he's come to you and asked to meet with you before. What's your opinion?
My opinion is no,
Is that-
I mean,
no?
if he's done this to, he's tried to do this to several people, and people just ignore him, and he goes away, so he's never had the opportunity to really follow through. That's what it sounded like. Your client obviously would know more, I don't know. But my opinion is, no, it didn't surprise me, because he was very surprised. He was ambushed with the call, but then he was certainly able to carry the conversation, most of it for almost 20 minutes. Surprise call that he never expected in a million years, apparently, and he might have said something like that, but I won't swear to it.
Okay. So, on the call, or you said you wanted this to be a one-call kind of a situation, meaning like, you wanted this to be, how to characterize it, what do you mean by that, just to be sort of like one and done, make the call, then we've got him?
Well, I just wanted the process to be the least intrusive method on me and my life. That makes sense.
Yes,
The
that makes
police,
sense.
investigators, they do their job. I'm a cooperating victim. The least amount keeps me from being more victimized, I guess would be a sad way of saying it, but I'm just trying to describe it and answer your question.
Right, and, in fact, you asked him, what do you want me to do? Do you want me to, reverse my ruling, or remove the contempt? And do you recall, you asked him that?
Yeah, it was, I was trying to suggest things, give him some ideas that he would agree to right there and then.
Yeah.
Throwing out some random crazy things that are way off the charts in my mind, but
Right, I believe you
What would
testified that on direct, that I can't believe I was saying this sort of thing.
Yeah.
But he rejected that, right? He said, no, I don't want you to reverse your ruling.
I don't remember right now, whatever I've said is fine. I don't remember what his responses are. All I know is he didn't agree to any of what I said, because obviously we had to ask him to, or I had to ask him to send me an agreement. He didn't agree to any of my, we'll say, crazy suggestions, like reversing rulings or doing something to his record. I was just making things up of things that somebody who shouldn't be on the bench would possibly do. So it's very surreal, but yeah, he didn't agree.
Okay. And, okay. And- All right. So, okay, so you asked him, all right, so he said no, and then, so you wanted, was that also the, sorry, I'm losing on those notes, that you wanted something in writing, and everything you, meaning the three of you, I guess,
He
wanted something in writing, is that correct?
He said no. I don't think he said no. Maybe the officers have a better recollection. All I know is he didn't agree. I don't think he rejected anything. I don't recall. I can say that he did not agree to it. I don't know that he said no to anything. I don't recall either way.
Right.
The officers probably do. I don't recall that.
But I mean, right, he
I just-
just wanted to meet with you, right? You said he just wanted to meet you, but he
sound-
wanted to talk to you, he wanted just to,
He sounded like a man obsessed, and he insisted he had to be in my presence. He
Okay.
had to come see, I mean,
but
I've
it
never
wasn't
had,
his intention to formally.
Time, please.
sorry,
Pardon?
one at a time. Your
It
turn,
wasn't
sorry.
his, he wasn't, intending to send you anything in writing, he wanted to meet with you from that conversation.
He did not desire to do anything but be around me. He wanted to be around me, and I didn't want to be around him. That's in a nutshell.
Understood.
Special, a disgruntled criminal, a criminal defendant in a case, or at least a traffic matter, whatever you want to call it. It's not a good idea say, hey, come on, let's go hang out, let's have some beers or something. It just doesn't happen in the real world. It does not ever happen, and I wouldn't want it to happen.
Right.
I just wouldn't. I mean,
But at this point, you didn't have any case with him, when the case was done, I mean, it wouldn't have been.
oh, with the, but I did a lot of digging into him. I knew,
Okay,
let's,
okay. All right, at this time, we're gonna take a recess. Okay, during this recess, you're admonished not to discuss or communicate with anyone, including your fellow jurors in any way regarding the case or its merits, either by voice, phone, email, text, internet, or other means of communication or social media, or read, watch, or listen to any news or media accounts or commentary about the case, do any research such as consulting dictionaries, using the internet, or using reference materials, making the investigation, test the theory of the case, recreating the aspect of the case, or in any other way investigate or learn about the case on your own, or form expressing an opinion regarding the case, till it's finally submitted to you, will be in recess for 15 minutes. Okay, the record reflect that the hearing is taking place outside the presence of the jury panel. You know you can't testify about any digging or anything about Mr. Blandino. You understand that, right?
can't talk about his, yeah, whatever you say, Ron, of course.
Right. I mean, I didn't know what you were gonna say, so that's why
I wasn't gonna talk about felony or kidnapping children or anything like that. It's just a matter of, my state of mind is I did some research, and based upon that, I wasn't gonna go any further. I figured that's why,
Yeah, I just wanted to make sure.
of course,
All right.
Thank you, Your Honor.
thank you.
Thank you. Will please be seated?
This is stipulated to the presence
We do, Your Honor.
of Mr. Bateman.
Yes, sir.
Excuse me, continue with your cross-examination.
Thank you. Hello again. Hi, Federico. Okay. Let me, I'll sort of switch gears here. Now, Mr. Federico never verbalized like any physical threat of violence against you.
Did you mean Mr. Blandino?
I'm sorry, Mr. Blandino.
I'm sorry,
Sorry.
physical threat,
Right,
rather than,
Mr. Blandino never verbalized any physical threat of violence against you.
no, it was all me inferring.
Okay, so any fear that was created, you created in your own mind. You drawing inferences.
Except the time that we thought we saw his vehicle around us over at Polk Park, and the time that my wife thought she saw someone look like him across the street from our community. She was with the kids.
Okay.
So there
And
was,
those turned out not to be him.
I don't know.
Okay. And, so, then also, going back to these, and just to be, not to go through all of these, letters and stuff, I mean, what monetary relief did Kim ask for? It was $25?
$25, it was the $500 and or me spending money to go to Reno to take some kind of classes. There was a apology.
Okay.
That's all I recall, the documents or evidence.
Right. And, but, I mean, he told you the $25 when he asked for it. In the next paragraph there, he states that that money is to go to someone else. It doesn't go to him, correct? That money was to reimburse them.
Calls for speculation, Your Honor.
Sustained.
Okay. In there, I believe it's, there's a hold harmless clause. Can you explain to our members of the jury, what is a, like in contract language, civil law, what is a hold harmless clause?
Somebody is going to receive some, for example, if you settle a case and you have, if I'm a plaintiff, I get money because somebody else, because you're my attorney, and the insurance company gives me money, but I still owe my medical providers, I'll sign an agreement that says, well, for giving me all the money, I will hold you harmless for anything my medical providers might try to do to you to get paid, because I got the money now.
Correct.
Makes sense.
And in that settlement release, there is a hold harmless clause, correct?
Correct.
Okay. That says that you will be held harmless, or the $25 that you pay, you will be held harmless from the person to whom it is owed.
It's not my writing, I think so.
Okay. And getting to that, it's not your writing. I mean, look, you had interaction with Mr. Blandino at the trial in 2018. And clearly, this document is not his writing either. Would you agree?
I'm speculating, I'd speculate that part of it is and part of it isn't.
I just want your opinion. So
My opinion is some of it might not have been. A lot of it was like the death clauses that caught me off guard because I read releases and settlement agreements, as you said, quite often. That was way out there.
But I mean, what's a survivability clause is standard in many contracts.
Maybe with like NBA players or NFL or big corporate deals, I don't know, I don't deal with those. But in regular personal injury setting, I don't think so.
But the concept of a survivability clause is not foreign to you.
No, we learned that in Contracts 101.
Yes, first year law student could tell you that, correct? And so, I mean, so you stated your opinion, part of this was his, would you say was part his words, part not his words? I mean, would you think it's safe to assume that this was some sort of like cut and paste job?
Well, for speculation, Your Honor.
I'm asking his opinion, I think he can testify his opinion here.
I believe that's outside lay opinion, Your Honor.
Well, I mean, the witness isn't necessarily a lay person either. I mean, he's an attorney. I mean, if you're asking him what's his opinion based on reading the
Yes.
documents. Go ahead.
Oh, thank you. I would say part of it was taken from somewhere else, some standard contracts as I've done in the past. And then you modify it and add your own paragraphs to fit your needs, underlying reasons. I would say it would be called a hybrid. That's what I believe, just because.
And that's pretty standard. I mean, attorneys don't like reinvent the wheel with every contract or pleading. It's standard. You have something, you might pull language that applies here and use it. Is that accurate?
I do.
Okay. And, okay. And I mean, and in that, I believe on your, I'm sorry, in your correspondence, or in the correspondence from Mr. Blandino, he states that he is, what was it, a volunteer, an unpaid volunteer investigator. Couldn't you draw the inference that unpaid volunteer is unofficial?
No, I wouldn't.
You wouldn't?
No.
Okay.
I mean, I'm
So-
an unpaid volunteer for the State Bar Fee Dispute Committee, but
Okay.
I can't just say that unless I have the letter that's confirmed by the State Bar telling me that I'm allowed to do that, otherwise I'm outside of their authority, and I'm doing things, I'm having apparent authority.
Okay. Now, but I mean, you knew him from the trial in 2018. You knew he was not any official type of person with the Nevada Commission on Judicial Discipline.
He said something about himself during that trial, about being an investigator. I just blew it off because I don't let people use like name tags and stuff like that coming in my court influence me. He said something
Okay.
about it. But I can't say there was a judicial.
But I mean, you have contact with them, you said you've been trained by them every couple of years, and you get training from them?
CLEs, yes.
Okay, yes. And, so, it's safe to assume, you knew he was not in any official capacity with the commission?
Honestly, I felt like he wouldn't have been, but there was also the possibility that he was some kind of rogue person. I just didn't know.
Okay.
It didn't make a difference anyway, I didn't think it was appropriate, I felt like this wasn't the way a person should be doing things if they do have that title. But I really didn't know, I'm just speculating.
All right, thank you. And going to the, going back to your phone call with Mr. Blandino, when, as you stated that he wanted to meet with you and you said no, and finally you got the hint. Say, please send me something in writing, because that's what the detectives wanted you to say, correct?
Correct.
Okay. And you had no intention of working anything out with him, correct?
Correct.
Yeah, I mean, you weren't, but you led him to believe that you were dealing in good faith, that you would respond to what he was asking for, correct?
I made him think I was taking the bait.
Okay. So, and, I mean, in this, now, you stated that your job is a civil litigator. I'm assuming you negotiate settlements, is that fair?
Fair.
Okay. And, do you ever, I don't know, are you familiar with the negotiation technique of what they call high anchoring? Where, are you?
You mean a cabinet floor?
Yes.
I don't know what high anchoring is, you caught me, but
Okay.
a floor and ceiling when you're trying to negotiate and you do brackets, maybe in mediations.
Okay. High anchoring more refers to, okay, I'm gonna obviously ask that my first offer be super high, right? So that, because, yes, I'm willing to settle in here, but I'm going to, somewhere in the middle, but I'm gonna ask, obviously, for something.
Trying to make a good midpoint for yourself, I understand what you're saying.
Correct. And, so, Mr. Blandino is, in his mind, I mean, from what he's saying to you, he wants to negotiate. He wants to enter negotiations, correct?
Correct.
And you led him to believe that you would work something out with him, that you would respond to his, request, correct?
Correct.
And, so, and in fact, I mean, that's why law enforcement was there, wanted something in writing, right? I mean, that's what you were there, you were trying to get him to slip up, correct? I mean,
Well, he started something and they wanted to make sure that if he was gonna finish it, there was no loose ends, I guess.
and, right, and so.
I didn't ask him to come to my office the 2 different times,
I
and I
understand.
tried to bait him in, he came, started it up, so.
Right, so why, again, it goes back to the question of why didn't you ignore him?
I had never been in that situation before, and I didn't think it was something to be ignored, since I immediately thought somebody's trying to extort from me. That's why.
But, I mean, by calling him and asking him what he wants with law enforcement, something in writing, I mean, you led him down this path, correct?
After him coming to my office twice and finding me in my office, yes.
But you
But-
changed the rules. He wanted just to meet in person with you, you, at the insistence of law enforcement, changed things and said, no, give me something in writing. Correct?
I apologize, could you say that again?
Your test was, he wanted to meet with you more than anything else in that phone conversation. But you, at the insistence or the urging of law enforcement, sort of changed that and said, no, give me something in writing. Correct? And so, that's what I'm saying, so you led him down a different path than what he had originally had wanted, which was just a face-to-face meeting.
I'm not sure I'd call it a different path. I would just say it was modifying things, not agreeing to his initial terms and saying, hey, let's do this in writing.
Okay?
And then it kind of, sorry.
And then, so, all right. So you and so he did that, and then you were told by the detectives to follow up with that May 9th email, correct?
Correct.
You led him down the path and said, hey, because he thinks he's negotiating, he thinks he's working something out with you. Probably expecting a counteroffer or something of that effect. And then they ask you to ask him for what, a global resolution?
They did.
And what does that mean?
What does that mean? What does that mean? Well, you have the second time he came into my office, I'm sorry, the second time he was in my court, where he said I committed misconduct, and that's where he focused his original documents on. But the original complaint started with the trial that was in 2018, so globally means let's wrap up both of these, because all he's doing initially is talking about the second time he was in my court. And of course, you want to cover all bases and take care of any possible claims that would, I guess, include the trial as well, all the complaints he had against me about the war and stuff like that.
Okay,
That was the global as far as my understanding.
all right. Courts and indulgence. And but well, sorry, just to get back on that, he only was trying to, I guess, resolve being kicked out of the courtroom, the April 25th incident, correct?
Objection, calls for speculation and best evidence.
Sustained, you probably just need to clarify it.
Okay, well, you asked for the global negotiation because his proposal only included dealing with the incident on April 25th.
I believe so, correct.
Correct. And and you So you wanted to, or with the help of the, the assistant officer, to lead him down, this path, right? I mean, you did, you changed what he was seeking to suit your own purposes.
I can't speak for the officers, I was just following direction. I
Okay.
think I'm respectfully talk about that.
All right. I will pass you, Mr. Chairman.
Any redirect?
Thank you, Your Honor. Would have been great that on April 29th, 2019, you call Kim Blandino and he says, hey, I'm so glad you called, that's all I wanted, let's go our separate ways, right?
Right.
That was not what that conversation was it?
No, I don't know.
And it had only come to the point on April 29th, 2019, that you're calling him in your conference room with two law enforcement officers there listening in after Mr. Blandino had shown up unannounced at your office on April 8th,
Yes,
left a letter that day that he wrote indicating, I'm ready to start filing my complaints.
yes,
You need to negotiate with them.
yes,
And then showing up for no particular reason other than his stated reason of investigating you in your courtroom on April 25th, 2019.
yes,
And then later that day, showing up unannounced, unwelcome, after you kicked him out of the courtroom for coming to your office, back to your office.
yes,
This time with a new letter that was typed out.
yes. He didn't write anything that day. Dropped off that nice package.
And it was that. It was those events which ultimately led to you making that call to him on April 29th.
That's correct.
The pressure that he had exerted on you, which led to that day.
Great.
Now, there was some talk about taking him out of the courtroom on April 25th, 2019. And defense counsel had mentioned that there was other people in the courtroom, right? And they were allowed to sit in there, that we saw on video.
I think there was quite a few, because I remember comments that were made afterwards by some.
Has any of those people shown up unannounced at your law office after you convicted them of crimes in court?
Never,
Had any of those people dropped off a letter that you felt were threatening at your law office?
never,
Had any of those people in that courtroom ever threatened you before?
never.
Then there was discussion about that phone call in particular. The conversation that you had with him, did you ever suggest to Mr. Blandino that you should pay him $25?
Tell him that I believe I should?
Yeah,
No,
did you ever suggest that?
no,
Did you ever tell him that you should pay him or pay to the Clark County Law Library $500?
No.
Did you ever suggest that you should take this class in Reno in October of 2019?
no,
Did you ever suggest that you should, as in your capacity as a judge, issue a written apology?
no,
That you should acknowledge in that written apology that he has the right to come and view your courtroom at any time and investigate?
no.
And there was some discussion about whether some of the language in that document titled Settlement Agreement and Release that Mr. Blandino had sent to you seemed to be maybe a copy and paste. You remember that?
Yes, on cross.
Is there any template for seeking a quid pro quo from a judge that you can just find online?
I doubt it.
Objection.
I've never looked for something like that, but
Sorry,
I,
what's the objection?
sorry.
I think that miscategorizes that settlement, man.
That's what that's.
Overrule, you can take it up on recross.
I apologize, what was the question? Oh, yeah. I'm not familiar with anything like that, I've never seen anything like that before. I can't say it's not out there though, I mean, that would be, I just don't know, but I doubt it because it wouldn't be an ethical document.
Yeah.
So, I guess on maybe the dark web or something, I don't know, I'm just obviously speculating.
You've never seen it.
No,
Um,
that's like make-believe land in Lawyerville, you know, I mean, it just doesn't.
Because when you get an adverse ruling from a judge that you don't like, there's no template to search for to send that judge your terms for their personal service to you, to release whatever you believe you have to them, is there?
No,
And you discussed these death clauses that you saw in that document that said, if you die, the $25 is still owed to Mr. Blandino by your estate.
it was all my death, not anything to do with him possibly dying during the terms of the contract, so.
Right. And if you die, the $500 is still owed by your estate to Mr. Blandino.
Right, I think for him to distribute when he feels like it, I guess.
Okay. That was concerning to you,
Oh, yes.
and you testified you felt that was a death threat?
Oh, yes. There's two of them in there.
Defense counsel had asked you, insinuating that you changed the rules. You changed the rules by asking for something in writing, is that right?
That's what he asked. I mean, that's what he suggested.
Did you ask for that note on April 8th, 2019?
Absolutely not.
Did you ask for Kim Blandino to come drop off that letter on April 25th, 2019?
No.
And in the follow-up letter or email that you sent to Mr. Blandino on May 9th, 2019, about the global agreement, there was some question about that, right?
Yes.
And I have here, states Exhibit 7, putting it back on the screen. You sent that email at 9:20 a.m., is that right?
Whatever it says, I don't remember, but then whatever the time is, I'm sure is accurate.
Is that the time there for your email?
Yes, off the law firm email,
Okay.
which is very important when you're sending emails from law firms.
And then Mr. Blandino responded to you an hour and 28 minutes later
Yes.
with this letter. Is that right?
Yes,
The one dated from the day before, May 8th, 2019?
yes.
One where when we turn to it on the last page, the one that he indicates, I have worked on this letter now over the course of 2 days. Is that the same letter?
Yes, it is.
The course of 2 days, so somewhere around May 7th, May 6th would probably be about that?
I believe so.
Okay. Defense counsel had asked you, why don't you just ignore him? Remember that?
Yes,
If you never heard from Mr. Blandino after April 8th, 2019, when he dropped that note at your office, would that call have taken place on April 29th?
I apologize, I didn't hear that first, I wasn't following.
If you never heard from Mr. Blandino again after April 8th, 2019, when he came to your office, stood around for approximately 20 minutes, and wrote that note, Would you have ever been sitting in your conference room on April 29th, 2019?
Object, Your Honor, calls for speculation and then object to the question.
Overruled, I'm gonna allow him to answer.
So, if you never heard from Mr. Blandino again after he came to your office, stood around for 20 minutes, wrote a note indicating that you need to contact him to settle, you never heard from him after that date, would you have been sitting in your conference room or your deposition room with two law enforcement officers on April 29th, 2019, calling Mr. Blandino?
It's only because of him. His actions caused it all.
So,
I didn't want anything to do with the guy.
so if you had never heard from Mr. Blandino after April 8, 2019, and that note was dropped at your office, would you have been sitting there calling him?
No, never.
If Mr. Blandino had not come to your courtroom on April 25th, 2019, and then later that day come to your office and dropped off another letter indicating further that he wanted you to contact him and that he was gonna file a complaint, would you have been sitting there in your, if he never did that?
Never did any of that stuff. No, there'd be no reason to. He engaged me first and came at me. So instead of going back at him, I went to law enforcement.
If that traffic trial in August of 2018 was the last time that you ever saw Mr. Blandino, how would you feel about that?
We were in a much better scenario.
And would you have ever been sitting in that deposition room on April 29th, 2019, calling Mr. Blandino?
No, no reason to. It would have been forgotten.
And ignored?
Right.
Okay.
It's another trial I heard for the taxpayers.
They're the best witness.
Angry Cross?
No.
Okay, thank you very much for your testimony here today. You may step down, and you are excused from your subpoena. Thank you very much for being here the last couple of days.
Thank you, Your Honor.
I'm going to call your next witness.
Thank you. State will call Paul Deyhle.
You do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Please state and spell your first and last name for the record.
Paul Deyhle, last name D as in David, E-Y-H-L-E.
Thank you very much. Sir, what do you do for a living?
I'm an attorney for the Nevada Judicial Discipline Commission.
Okay. And this is the state of Nevada's Commission on Judicial Discipline, is that right?
Yes.
And what is your title with the Commission on Judicial Discipline?
I'm a general counsel and executive director.
Okay. So does that mean that you run that commission for the state of Nevada?
Yes.
And can you tell us how long you've been doing that job?
Since November of 2013.
What's your background before coming into your position with the commission?
I was a partner at McDonald Farnham Wilson Law Firm for about 14 years in practicing in corporate business and intellectual property law.
Okay. And so moving over and running a state commission is different than practicing law, is that right? Like in a civil practice?
Oh, yes, much different.
And can you just tell the ladies and gentlemen of the jury, what is the Nevada's Commission on Judicial Discipline?
It's a commission that investigates judges based on complaints or allegations of judicial misconduct and incapacity.
And how is the Commission on Judicial Discipline structured?
It has 7 commissioners, 3 are appointed, 3 lay members are appointed by the governor, 2 judges are appointed by the Supreme Court, and 2 attorneys are appointed by the Board of Governors of the State Bar of Nevada.
And so what is the commission's role, those 7 people?
They decide, those 7 commissioners decide on whether a complaint moves forward in the process, whether an investigation is authorized, whether discipline is imposed.
Okay. This commission itself, and just the commission as a whole, the entire body as a commission of the state of Nevada, does that have its foundation in being created within the Constitution of the state of Nevada?
Yes, it does.
And are there laws within the Nevada revised statutes that deal directly with the Nevada Commission on Judicial Discipline and its structure?
Yes, it's NRS Chapter 1.
And then within the state law, does it also dictate that the Commission on Judicial Discipline has its own procedural rules that have to be set?
Yes,
And does that in fact exist within your commission, sir?
yes.
Can you tell us about the way that the Commission on Judicial Discipline investigates judges, the process that occurs?
The commission, once an investigation is authorized, the commission has authorized, they have authorized investigators, essentially, that are, they're engaged, they're not employees of the commission, they're independent contractors that the commission engages to conduct the commission's investigation.
And when you commission, when you get these investigators and you commission them, they then become agents of the State of Nevada's Commission on Judicial Discipline?
Yes,
And the State of Nevada's Commission on Judicial Discipline, their investigators have special authority under Nevada law, is that right?
yes.
What does that authority include?
It includes when an investigation is authorized, speaking and interviewing judges, witnesses, requesting transcripts, videos, and other documentation that's needed in the course of an investigation.
So they have the ability to, under the state law, to compel witnesses by subpoena
Yes,
and to compel the production of evidence by subpoena.
yes,
There's also state law which deals directly with certain individuals having to cooperate with your investigators by law.
yes.
And what is that? What is that generally, what is the law generally there?
What, the law is what?
What does that authority generally mean? What is that?
Well, if our investigator needs to, in the course of an investigation, needs to speak with a witness, get documentation, the public officers of the court, state employees, they are required by law to cooperate with the commission and further and furnish any information, transcripts, documentation that's requested.
Okay. Now, the investigators that you bring into your investigations, where do you find them?
We've had the same investigators for a number of years now, Spencer Investigations, and we've had the investigators, they're individually, separately licensed under Nevada law as an investigator, and make sure that they're licensed, conduct interviews, and we engage them.
Okay. And these are professional investigators?
Yes, they work not only for the commission, but in other capacities.
And they're licensed by the state?
Yes, they are.
And when your commission brings them into an investigation, they become public officers?
I believe so, yes.
And can you talk to us about how the Commission on Judicial Discipline begins an investigation?
Well, the commission receives a complaint, and commission staff, myself, other attorneys, will review the complaint. We will request any videos that may be pertinent, and we'll draft up a recommendation, which includes the facts and the law, present that to the commission for its next quarterly meeting, and then the commission will decide what the next step is. If there's that meets that evidentiary threshold at the beginning for an investigation, they'll authorize an investigation, and that will proceed accordingly. If it does not, then it will be dismissed. And then, well, I don't know, do you want me to go forward?
That's fine right there for this portion here. As far as a complaint, where can you get complaints that you start taking action on?
Where do we get them from, or where
Yeah.
can a complainant get the form?
Where do you get complaints from?
From anyone who wants to file a complaint with the commission.
Anybody in the public?
That's correct.
And you receive their complaints,
Yes,
and then your office begins the initial investigation.
yes, the initial investigation is really comprised of requesting videos from courts throughout the state, if applicable, or transcripts. That's all that the staff can do at that point. So the commission has all the information it needs at that preliminary stage to decide whether there is enough of evidence to move forward in the process. The commission has to authorize an investigation for a full investigation.
And once the commission authorizes the investigation, is that when an investigator for the Commission on Judicial Discipline would be retained to work on that case?
Yes,
And the commission, to open an investigation, needs to find that there's a specific burden of evidence that's been met. Is that right?
that is correct.
And am I correct that the commission looks at each one of those initial investigations to determine specifically if there is objectively verifiable evidence from which a reasonable inference could be drawn that a judge committed misconduct or is incapacitated?
Yes, that's the initial evidentiary threshold to determine whether an investigation is going to be authorized.
Okay. And then, once that investigation is, if it is not authorized, what happens?
It's dismissed or a letter of caution is issued to the judge.
And a letter of caution would come with the dismissal?
Yes,
A letter of caution, is that discipline?
no, it's not discipline, it's not made public. It's just a letter to the judge.
And is it a finding of misconduct?
No.
Okay. And so then let's say that the commission finds that there is objectively verifiable evidence that that can draw a reasonable inference that a judge committed misconduct or is incapacitated. What happens at that point?
The commission will authorize an investigation, will engage the investigators, and then they will proceed to interview the witnesses and the judges, review documents, and then after that process is completed, they will prepare an investigation report and submit that and all materials, transcripts to the commission. And then that process will start again. Recommendation is prepared, and the commission will then make a decision whether the investigation substantiated the allegations or not.
Okay. And so this is now the second phase of the investigation. And it's completed when the investigator completes their side of it, completes an entire report on their investigation and submits that to the commission,
Yes,
as well as all the evidence they've collected.
yes.
And then what does the commission do at that point in time once they have all of that in front of them?
Well, then the evidentiary threshold changes at that point, and it becomes a reasonable probability that there's clear and convincing evidence that misconduct occurred. So it goes from objectively verifiable evidence to clear and convincing, which is significantly higher.
And so at that point in time, what if the commission finds that the investigation doesn't meet that burden?
Again, it will be either dismissed and/or a letter of caution issued.
Okay. And what if they find that the investigation does show very convincing evidence of misconduct or incapacitation?
Then they will authorize the judge, well, they'll require the judge to respond to the complaint.
Okay. Is any of this public?
No,
Up until this point, none of it is public.
that is correct.
And then what happens when the judge responds to the complaint?
Then the commission will meet again and review the response and make another determination, same reasonable probability of clear and convincing evidence, and determine whether formal charges will be filed.
And so if the commission decides that after receiving the response, there is not enough evidence to meet that burden, what happens?
it'll be dismissed and with or without a letter of caution.
Okay. And if they decide that there is enough evidence to proceed, what happens at that point?
Then they'll authorize the formal charges to be filed by a independent prosecuting officer.
And what is an independent prosecuting officer?
Independently licensed Nevada attorney that the commission engaged. Again, it's not a commission employee. It's a licensed attorney that has a separate practice, but part of that practice is working for the commission.
Okay, and when they're working in that capacity for the commission, they are a public officer that is a prosecuting officer for the commission on that case.
Yes.
So they essentially become a prosecutor in a judicial ethics matter.
Yes.
And so then, what happens once prosecuting officer is engaged, formal charges are filed, what happens there?
Well, then it goes forward as any civil trial, if you will. As the judge, the formal charges will be filed, the judge will have a time to answer the complaint, and then it'll just proceed forward to trial unless there's a stipulation settlement prior to that.
Okay, so a settlement where the judge potentially admit that they did something wrong,
Yes.
and that would wrap up the whole matter with whatever the Commission on Judicial Discipline deems to be an appropriate sanction for that?
Yes, if the commission and the judge agree to the stipulated terms, then a document is created. It's public, and it's filed with the Supreme Court and posted on our website.
Okay. And does the Commission on Judicial Discipline, those 7 members who are appointed, they have to approve of that settlement?
Yes.
Would it ever be appropriate for a private citizen to go find a judge that they have an issue with and make their own settlement with that judge on behalf of the Commission on Judicial Discipline?
Absolutely not.
That's not how that works. And so then, if the settlement, if there is no settlement, the commission and the judge, who has now been charged by the commission, can't agree on anything, then it goes to a trial.
Yes.
This is a public trial.
Public trial.
The judge can have an attorney.
Yes.
The judge gets all the evidence,
Yes.
and it would be a trial just like we would expect a trial to be, essentially.
Yes. Rules of evidence, rules of civil procedure apply.
And I should also mention too that earlier, before those formal charges are ever filed, when the commission gives the judge an opportunity to respond, does the judge know what potential violations are pending against them?
Yes, yes, they get a copy of the complaint, they get a copy of the investigation report, all of the supporting documentation that was involved in the investigation, including transcripts, videos, audios of interviews, anything that the commission relied on to come to offer, to require the judge to respond. The judges sent these materials prior to having to respond.
And so the judge is afforded due process.
Yes.
And then ultimately, we go forward if trial is held and the commission finds that there is sufficient evidence to find the judge committed misconduct or is incapacitated. What are the potential punishments?
There's a range of remedy, of sanctions or punishment, if you will, ranging from public admonishments and reprimands to fines, requiring the judge to take an educational class. For more severe cases, there would be removal or bar from being a judge again. Just
Okay.
depends upon the facts of the case.
And so a variety of things up to removal from the bench and being banned from ever being a judge again.
Yes.
Now, we talked about your investigators. Do you know who Kim Blandino is?
Yes.
And has Kim Blandino ever been an investigator for the Commission on Judicial Discipline? Has Kim Blandino ever been authorized by the Commission on Judicial Discipline to hold himself out in public and to judges as an investigator on behalf of your commission?
No.
Did you come to learn that Mr. Blandino, in fact, was doing that?
Yes.
And did that cause you concern?
Yes.
Why did that cause you concern?
Well, first and foremost, it's not true that he is not an investigator for the commission. But as you said earlier, investigators have certain powers under the law to compel witnesses and others to comply and furnish documents and information. So if someone who is not authorized by the commission was acting in that respect, that would be very concerning.
As you sit here today, are you aware that Mr. Blandino and a municipal court judge pro tem, Michael Federico, in that capacity, had interactions in the Las Vegas Municipal Court on August 28, 2018 and April 25, 2019?
Yes.
And you're aware of those interactions?
Yes.
And can you confirm whether the Nevada Commission on Judicial Discipline ever filed charges against Michael Federico for either of those interactions?
I can confirm that no charges were filed.
And can you confirm whether the Nevada Commission on Judicial Discipline ever found it appropriate to discipline Michael Federico for either of those interactions?
No, no discipline was imposed.
State of pass the witness.
Any promise?
Yes. Good afternoon, Mr. Is it Deyhle? Is that how I pronounce
Yes.
it? Doing it right? Deyhle? Okay. You stated that your title with the commission is executive director
Executive Director and General Counsel.
and general commission, okay. And also, I'm sorry, when I say the commission, I mean, obviously, the Nevada Commission on Judicial Discipline. I'll probably just say commission, just to be brief.
Sure.
Okay, and, now on direct examination, you, stated that the commission responds to, it responds to complaints. I mean, in other words, it doesn't generate its own, cases, as it were. It's in response to complaints from the general public, or from whatever source.
Yes, there is one exception, that if information comes to the attention of the commission and a complaint has not been filed, then under the law, as executive director, I have the authority to file a complaint myself upon authorization by the commission.
Okay, but, okay. In fact, that's a very small percentage of the complaints that are generated that would be generated by you or by the commission, as it were.
Yes.
In fact, now the commission creates an annual report or biannual report.
Both, yes.
Okay, and those reports are required by law, correct?
Yes.
Okay, and so I do have the report for, I guess, yes, the pie chart that comes out with that, I'm sure you're familiar with the report. There's a, basically breaking down the source of complaints, and another for year 2021, and the commission generated one complaint. Does that sound right?
One complaint, I didn't look at that,
Right.
but It's a low number.
Okay. And, okay, and, so yes, so most, and, so it does, so the commission does rely on complaints from third parties really before it will begin to investigate any claim of judicial misconduct.
Good.
And so, and just sort of to recap, so a person sends a complaint into the commission, and then you or someone on your staff reviews that complaint, you said reviews, transcripts, other evidence to judge its merits, correct?
Well, the staff, the council does, they don't judge the merits on it, the commission does.
Okay.
We just present it to the commission for determination.
Now, is that with every complaint, so is that decision made by the commission, by the commissioners?
As to whether a complaint moves forward or not?
Yes.
Yes,
So is every complaint then forwarded to the commissioners?
yes.
Okay. Do you make recommendations with, when you send that over? Does the Okay. And, so it's possible then that, so one of the possible outcomes you said is just, after initial review, we're just going to dismiss this outright? Is that your?
Well, if the commission determines that, if
Right,
it doesn't
that's
meet that
correct.
evidentiary standard yet.
Also, you stated that it could also be dismissed, but with a letter of caution to the judge.
Yes.
And what does that entail? Like, what would you, if you're dismissing it, what would you caution the judge in that sense if it's dismissed?
Well,
Maybe you can explain to our viewers here, why, if you're gonna dismiss it, why are you cautioning the judge?
well, the commission, on the allegations, if the commission decides to dismiss certain allegations and not others, or they decide to dismiss and they see other things in the file, in the video that is concerning, they will send a letter of caution to the judge. Just, it's just bringing certain things to the attention of the judge, so the judge is aware.
Okay. And, now, is it true that sometimes a complaint will come in and the commission will request of the complainant more information or more, I don't know, more evidence?
Well, during an investigation,
Yes, anytime in that
Yeah.
process.
the commission investigator will interview the complainant along with the judge and other witnesses, as the case may be.
Okay. So, and then these people then, I mean, I guess these complainants will voluntarily comply and provide you with what you're asking for.
Well, the commission investigator will meet with the complainant for an interview and will ask the complainant questions. And, at some point during that interview, if the complainant brings up documents that may be relevant, the commission investigator may request them from the complainant. But that's, just on a case-by-case basis. A lot of times, it's just an interview, they're getting information, there's no information to be provided, and it just goes forward from there.
Okay. And the, so it was your testimony on direct examination. The commission itself does not employ investigators.
That's correct.
And in fact, they're independent contractors, I believe is your testimony.
Yep.
But you don't use their services until it's determined that a case has merit, correct?
That is correct.
Is it, I mean, I can't read the notes. So, can you remind us, so they're asked that, what is it, the clear and convincing standard, is that when you're saying, okay, we, clear and convincing evidence that there's, potential misconduct, so we're employing these investigators to research it further?
The evidentiary standard at the beginning to determine whether an investigation is going to be authorized is objectively verifiable evidence that misconduct occurred, so much less standard.
See, okay, so I didn't have that one.
objectively verifiable, and then it goes to the next, if there is objectively verifiable evidence, it goes to the next phase, which is what?
A reasonable probability that there's clear and convincing evidence that misconduct occurred. That's after the investigation is complete.
Okay, so is that objectifiably verifiable, is that when you employ your contract, your investigator?
Well, yes, once if the commission decides that they have to make that determination that they meet the evidentiary threshold, and if they do, then they will authorize an investigation, and then commission staff will get in touch with the investigators and inform them.
But that's only after quite a lengthy process of a complaint being submitted to the point when you would employ your contractors, correct?
Well, from the time a complaint is received, and it could be 3, depending on when it is received, because the commission meets quarterly, so every 3 months, so it could be a month, 2 or 3 months before an investigator is authorized, just depending on when you receive that complaint.
And, okay, so in other words, there's nobody employed by the commission to investigate and commence an investigation, correct?
Before the commission authorizes one?
Yes.
No, other than what I said earlier on direct, that the commission has the authority to request JABs, videos or transcripts to assist the commission in making a determination.
Okay. But you said that was very rare. Most complaints come from
Well,
outside the commission.
Well, no, what I think what I said was rare was as executive director filing a complaint when one has not been filed. So that's rare. But as far as staff requesting videos, transcripts with respect to a case, that happens quite often.
But that is in response to a complaint that's been submitted?
Yes.
Okay. And so those complaints originate from, attorneys, the general public. I believe I saw that pie chart. There was quite a few
Yes.
inmates that generate these complaints. And then all of them are evaluated and end up somewhere in this process of being dismissed or dismissed with letter of caution or, further investigation is needed.
Yes.
Right. Okay. And, okay. Right, so, and you stated that you are familiar with Mr. Blandino, correct?
Oh, yes.
And I'm assuming he's, well, he indicated that he was an unpaid volunteer investigator for the commission. Wouldn't you infer that unpaid volunteer isn't anything that is official?
I wouldn't agree to that.
And, but the position of investigator, you said there's no investigators on the payroll, right, of the commission?
Not as an employee.
Okay, and so, and certainly not in the beginning stages of a complaint. It relies on the complaints generated by the public, attorneys, inmates, litigants, whomever, but, right?
Yeah.
Okay. And so, Mr. Blandino is, as a private citizen, is certainly welcome to file complaints with the commission. Is that correct?
Yeah.
Okay. In fact, you said as much to the Supreme Court, I believe it was last year, you addressed the Supreme Court, and you said basically the same thing, reiterated what you said on direct examination, that he's not you're not affiliated in any official capacity with the commission. Do you remember saying that?
Yeah.
Okay. Do you remember also saying, though, that he was, well, quote, tell me if these are accurate, that Mr. Blandino Can certainly investigate judicial misconduct on his own if he wishes, as do other individuals and organizations throughout the state, and file complaints with the commission. Those complaints have been and will continue to be considered just like any other complaint received by the commission.
Yes, I said that.
And you said that, and that was what, within the last year or so? Do you remember?
Yeah.
Okay, and you still stand by that statement, that he is, as a private citizen, may file complaints with the commission?
Yes.
Okay, I'll pass the witness.
Any redirect?
Yes, Your Honor. Those statements to the Nevada Supreme Court, that was in a hearing that they were holding regarding the Nevada Commission on Judicial Discipline. Is that right?
Yes.
What specifically?
Well, it was a administrative docket petition that was filed with the Supreme Court, and the Supreme Court is in the process of revising the Code of Judicial Conduct and also reviewing the Commission's statutes and rules.
And that came up, Mr. Blandino came up because he had filed something to the Supreme Court about his opinion.
Yes, he submitted written comments.
And the comments that defense counsel just reiterated for you that you made about Mr. Blandino, just like anybody else being able to file complaints with your commission, those were preceded by you beginning your statement before the Nevada Supreme Court with, Mr. Blandino is not and never has been an investigator for the Nevada Commission on Judicial Discipline.
Yes.
Any response?
No, you're not.
Thank you very much for your testimony here today.
Thank
You may step down, you are excused from your subpoena, and you may call your next witness.